Right, well, hello everybody, and I apologise for dragging you all in at this ungodly hour on a Saturday morning. The decision was taken for me. I almost said forced upon me. That wouldn't have been inaccurate. When suddenly, I think about 10 days ago, it was decided in another place that there needed to be, quote, a full day. So I don't know who made that decision, but it wasn't me. We therefore have 5 hours, so we could be so ethical by the end of that. We've got 5 hours to look forward to, or not, as the case may be. We are definitely going from 11 till 1. We'll break at 1 for an hour. At 2 o'clock, we will resume, and I believe that Jessica Rowland is coming in for the 2 o'clock start. So I don't know how much we'll have left. I'm assuming that we will have some bits left to cover by then. And I thought, if anything, it would be good, if we haven't got much left, it would just be good to get Jessica's insights about being involved in disciplinary matters, so far as judicial reviews thereof are concerned. So she could perhaps give us any insights that she has gleaned from her professional involvement. But we'll see how we go. So what I'm basically saying is that I don't think we'd like to run up to 5 o'clock this afternoon, but I'm not making any commitments on how much earlier than that we will finish. Those of you that have had the misfortune of joining me for the couple of weekends recently on civil procedure will know that I can pretty much talk ad nauseam. Not often making much sense, but I can talk. But I'll try and stick to what's relevant. And certainly over the last couple of weekends when we've been doing civil, we've tended to finish a bit short of time. Well, short. We finished before the time ran out, let's put it like that. Anyway, I'm also very conscious that I'm used to addressing 6 of you, and 1, 2, 3, 4, 5, 6 of you are here again, plus another 4, obviously, that I haven't met before. So my name's Rob McPeak. My day job is as a principal lecturer at City Law School, based in Gray's Inn. I've been there, I don't think I told you guys how long I've been there, though. But it's been a long time. We'll leave it. I'll just draw a veil over it. So yeah, been there a long time. But this is my first involvement with the Guernsey advocate schools. So very much a learning curve for me, just in terms of, as I say, time management apart from anything else. But we'll see how we go. If at any point you have any questions, please feel free to shout out. I'm sure you do. Anyway, I think I'm more or less sound on the names of the 6 people that I've now spent 2 weekends with, but perhaps Gemma introduced herself, so hello to Gemma again. But I don't know the people on either side of you or the gentleman in the corner, so perhaps if we could just run along. Rachel, okay. Right, cool, thank you. And Ollie, okay, all right, fine. Well, welcome. So, yes, you'll notice that I've gone all high tech today, for me anyway. And, I'm now obscuring the display behind me. So I haven't quite worked out. I mean, am I obscuring it very much? No? I just kind of ducked down a bit. Okay, all right, we'll see how we go. But I just thought it might be helpful to have a look at some things, or be able at least to have a look at some things as we jog along. So let's kick off and see how we get on anyway. So yeah, as far as the start of the study guide is concerned, I'm going to be sticking reasonably closely to that. Those who've been involved in the civil procedure sessions will know. We begin with what I think is probably the most important single point for the Guernsey Advocate, which is the oath that you guys have to take. And you can see it in French there. I'm going to have to scroll down, I'm afraid, and get the English version up and running. So, yes, diligently and lawfully exercise the office of counsel against any person whomsoever, okay, which I think in the study guide I've referred to as Article 1. So, yes, not really a lot to say about that, except it seems to me that that really is referring to what being independent of external pressures having integrity in one's professional practice. Second one, not maintain any causes, either in pleading or defending, if they don't find them in their consciences to be good and lawful. Again, it seems to me that that's basically saying that you won't run an argument in your litigation practice that you don't consider to be reasonably arguable. So that's how I'm interpreting that. Well, I think that's a legitimate reading of that. Julia?
Are we supposed to know the French code by heart for the exam? Okay, so we can concentrate on the English.
Yeah. Unless you particularly want to learn the French version of it. Okay. All right. So yes, third article then. If it should come to their knowledge by any means, whatever that the cause is bad, whatever its state, they will no longer plead it and will abandon it entirely. So again, that's really, I mean, I think that's probably covering a multitude of sins, I might put it like that. It may be that evidential insufficiency results in the cause being bad. It may be that you've reached a conclusion that the evidence that you're relying upon is not to be relied upon. In fact, false evidence. Yeah, something along those lines. So as you can see, whatever its state, then we'll no longer plead it and we'll abandon it entirely. So no longer plead it would suggest that this could be kind of after the fact discovery. Proceedings have been commenced, and you will then perhaps either no longer plead a particular cause or the cause in its entirety. So a particular issue might have to be abandoned, or maybe the entire claim. So fourth one, in their pleadings, whether on behalf of plaintiff or defendant or replying, will not declare nor falsify any facts which those who instruct more attorneys have not said and declared to be true. So again, very obviously limited to pleadings that have been filed and served in litigation, not declare nor falsify any facts. So again, not misleading the court, not pleading things that you're instructed are not truthful, and great one, not falsifying any facts. So not making things up on behalf of your clients, perhaps saying something has been done that hasn't been done. So that's, I think, essentially what we are looking for there. The next one, advising or pleading, beg your pardon, not proposing nor alleging any fact, custom, etc., if they do not believe it to be correct and true. In a sense, I suppose that could be regarded from one angle as your duty to the court. Yeah. But of course, if you're simply advising, there may not be a court involved, so it may be best interest of the client. That might be another way to understand that. It could just be that you have to be providing a competent level of work because it needs to be legally accurate. So I think there are many ways to perhaps interpret that one. If they come to know anything in right of the Crown or anything which may affect the Crown in any way, they will make this known to the court. I think that's one of the things that perhaps touches on client confidentiality. Again, it's not the most kind of specific form of guidance there. It's very much, I guess, in the eye of the beholder as to the extent to which that should be understood as an exception to any kind of protection of client confidentiality. But it does seem to me that it does represent an exception to that. Next one, losing count now, I think this is about number 7. They will not strike bargains with their parties or their attorneys for any amount of cause or of any part or portion of any contested cause. So this would be we don't like success fees or conditional fee arrangements, that type of thing. And I just pause there because that struck me as an interesting observation. Just throw it out to you guys. Have you got any experience within your firms of a particular position as far as things like CFAs are concerned, or success fees of any shape or form? Is it your understanding is it completely verboten and never to be countenanced? Yeah, it seems to be perfectly consistent with that principle anyway. Okay. Number 8, won't remain in court to advise or state their opinion with a view to judging in any manner in any cause in which they were formerly advocates or advisors. Now I'm reading that, and you'll see from the text in the study guide, I'm reading that really as a kind of recusal point. So will not remain in court. I'm assuming remain in court in a different capacity, because it does go on to say with a view to judging in any manner, rather than just hanging around in court when it's not your case, that type of thing. But anyway, yes. So a recusal point there. And last one then, number 9, when the court asks them their opinion on anything, they will give their reply truthfully and with all bias put aside. Well, again, you could say that's just an illustration of an overarching principle of one's duty to the court, really. I guess implicitly it might suggest something that would be familiar to anybody that's certainly been through the BSB handbook in the last three and a half years. That generally speaking, advocates are not supposed to volunteer their opinion on matters to the court. So don't give an opinion to the court unless the court specifically asked you to express that. Okay. I think this will take me on to the rules, so I might just scroll down and then leave that for a moment. Anything else? No. Any thoughts or any points as far as that's concerned? Or are we all happy with that? Okay. I will assume happiness. All right. So the major enactment that we need to think about, we saved the rules of professional conduct for a little while. But the major enactment that we need to be familiar with is 2007 Guernsey Bar Law. Consolidated text, I think it has been amended. The version that you have, and for those of you, I'm sure you've all been studying the ethics study guide scrupulously over the days and weeks that have preceded this morning. But just to make the point, there are a number of appendices stuck at the back of it with the raw materials included in there. Of which I think appendix number 1 is the 2007 law. So to that extent, I'm probably wasting my time putting it up here, but I thought it might be helpful from time to time. So we'll see how enthusiastically I scroll through it, or just leave it to fade to that rather bizarre purple color that it went to about 5 minutes ago. Anyway, all right. So as the study guide points out, the 2007 law came into force in 2009, so we've got no excuses. We do have to comply with it. So really, I guess, kind of institutionally, the stuff on, now I'm paginated in my version, which I downloaded from the website, from the VLE, so I'm assuming that we're all on page 7 at the moment. If we're on any page at all, are we? No? Okay, it doesn't matter. I just thought I'd check, because yeah, these guys that do civil will know that I had a problem with footnoting last time. I'm hoping we've overcome that now. But anyway, we'll see how we get on. So, all right. So the Guernsey Bar is a body corporate, and as you can see, then it's given the power to guarantee the performance of obligations by other persons, and I guess that's the people that you guys aspire to be, Guernsey advocates. So as you can see, amongst the objects laid down for the corporate entity that is the Guernsey Bar, to encourage and promote the upholding of the rule of law, which I guess it will be doing via things like the oath and the rules of professional conduct, having an ethics module on the Guernsey Advocate course. Or what is this actually called, this course? Bar course? Is it bar course? Yeah.
That's what about is actually how can we complete it? You don't get no. You completed how to complete it.
You don't get the t-shirt. Right, okay. Anyway, I digress, as ever. Yes, all right. So maintaining high standards of professional conduct amongst its members. This would be one of those occasions where I could actually scroll down and we could actually read it as well as listen to me. or perhaps instead of. Let's find section 2. Keep going. Keep going. All right, yeah, okay. So, objects of the bar: encourage and promote upholding of the rule of law, promote efficient and fair administration of justice. Lots of things going on down here, but as you can see there, then maintain high standards of professional conduct amongst its members, protecting the public and others against the negligence and willful misconduct of any advocate. And I guess maybe the requirement to pass an ethics paper could be said to be an example of that. Although, as ever, frankly, with a professional ethics module, in my humble and personal experience, all it really manages to do is make sure that you are familiar with the rules. Yeah, so you end up learning a load of do's and don'ts. It would be wonderful for me to think that at the end of today, I've managed to make you all better people than you were when you walked in here this morning, but I'm a bit more phlegmatic than that. So, yeah, so we'll know the rules, and that's about it. And certainly my personal view is that the biggest enforcer, the most effective enforcer of ethical principles is you, against you, as it were. Yeah, so there's got to be it's kind of like the good version of you sitting on this shoulder as opposed to the evil version of you sitting on the other shoulder, whispering in each ear as we go along. And either that works or it doesn't, frankly. You may feel that maybe you pay more attention to the good little you sitting on this shoulder because of the risk of discovery or the loss of reputation. That's something that particularly small profession is very significant. I think that was a point that Mark Dunstan made last Saturday. Yeah, hard maybe to acquire a reputation as somebody that is a good and effective advocate, but fairly straightforward losing whatever reputation you currently have. So maybe it's partly the fear of exposure, the fear of damage to your reputation. I mean, I think, frankly, the fear of sanctions is a kind of almost a secondary point, isn't it? I mean, if you had some kind of disciplinary ruling against you from La Chambre, I'd struggle to see how it really makes a massive difference whether we've had, a public rebuke as opposed to a suspension, really. I mean, you're still, damaged goods, aren't you, really, after that? So either it's a risk that you're prepared to take, or it's not. And I don't think anything like this, frankly, makes that much difference, really, unless it helps you to assess the risks. But frankly, if you're into risk assessment, you're already setting off down a slippery slope, in my humble opinion. So anyway, protect the public and others against negligence and willful misconduct of any advocate. Yeah, all right, fine. I think the key phrase there is maintain high standards. So that's maybe the important point. Maintain effective complaints and disciplinary procedures. Yes, okay. You will know, I'm sure you've sat there, looked at your chamber's website and clicked on what complaints, how to make a complaint. Yeah. Seeing what sort of hoops clients or others have to jump through in order to get a complaint in. Yeah. And there's going to be some internal framework structure. Who's going to handle that? Yeah, all right, good. Excellent. And disciplinary procedures. So as we know, you've got La Chambre de Discipline, and that's basically it, really. Promote the education and training of advocates. Well, here we are. So I know you're not advocates with a capital A at the moment, but that's the object of the exercise, isn't it? Yeah, okay. So I think that's probably that. I mean, yeah, all right, encourage and promote study of law. Okay, well, in a very real sense, of course, that's what you guys are doing on the course as a whole, isn't it? So there we are. Okay, so what do we need to think about then? All right, as it says on paragraph 7, anyone who's admitted as an advocate of the Royal Court of Guernsey shall be a member of the Guernsey Bar. I'm on page 7. Yeah, no. No?
Do you mean paragraph numbers in your text?
No. Did I say paragraph number? Did I? Oh, okay. Sorry. All right, okay. Yeah, no, okay. Well, I mean, yes, I need to learn to listen to myself. Yeah. No, I just assume that everything I say is crystal clear and packed with meaning. But that shows you're listening. Yeah. Right. Okay. So yes, a public register maintained by the greffier, as if that Hawthorne didn't have enough to do, of every applicant's details. And as you can see, amongst the information recorded, so again, this is perhaps part of the, if you like, the cost-benefit analysis when you consider whether to break that rule, make that disclosure, etc., etc. Write that offensive letter to your opponent, signing your name rather than sending it anonymously. Yeah. Then yes, as it says there, the details of any professional conduct complaint proved against him, which obviously includes her, in any jurisdiction. That's exciting, isn't it? So if you've kind of got on the run, you're now here in Guernsey as a fugitive from justice. Yeah. If that fact is discovered, then it will go onto the public register, as well as perhaps other places as well. So the details of any professional conduct complaint and its method of disposal, any conviction or caution for an offence committed in any jurisdiction. This is pretty standard in my experience. So you can't kind of avoid any sort of publicity in this context or reporting obligation by saying, well, it wasn't within the bailiwick. You know, what goes on in Malaga stays in Malaga. You know, I mean, you can't do that. So that's not going to work. Punishable by a term of imprisonment exceeding 2 years. So we've got a kind of cut off there for what we might describe as minor offences. Yeah. Well, I mean, if I compared it to the BSB, Advanced Standards Board, this is pretty generous, really. Yeah. Fixed penalty notice, parking ticket, and anything bigger than that. So yeah, punishable by term of imprisonment, exceeding 2 years. Wow, fantastic stuff. Well, I can see why you're all here in Guernsey anyway. Right, good. Yes. Yeah. I told you, you know. Given the opportunity, I will talk. Yeah. I've got to stretch this out till 5 o'clock. Well, it wasn't me. Be assured on that front. I was quite happy 2 till 5. I thought, yeah, it might be a bit tight, but no, I'm back again tomorrow morning to observe. Yeah, but then I'm going home at lunchtime. What? No. Well, I don't know. Well, yeah, who knows? Well, since I'm being paid by the hour, probably not. No. That is not. No. That would be revision, I expect, won't it? Well, if there is, it'll just be me saying the same things again. And you just watch the recording. Maybe I just play the recording. Come in, switch that on. Yeah. Yes.
Because we have different versions. I just want to check that we're all in there.
Well, not under my hand, no.
And then yes. Does not have so the latest version. I've got one.
I've got one to borrow as well,
Yeah.
Yesterday. This morning.
Because I printed mine last week.
Well, yeah, I printed mine this week. I've only got, well, I've got 0 preface and then 1 through to 4. And 5 is what? AML? Yeah. Okay. All right. So that's been added in then, because I only printed this Thursday.
Yeah. So we've got the latest one, which is missing the fact. No, but then there were 2.
Yeah, there was a few, yeah.
Yeah, there's definitely, so then if there's two study guides, if there's a section 5 in Rob's study guide as well.
Yeah, so that's that one.
I like it. I just want to check we've all got the same material.
Well,
Yeah.
the all right. Well, I'm not the person that puts this onto the VLE, fairly obviously, given my technical ability. But certainly when I originally produced the study guide, it did have a 5th chapter, which was about money laundering, and which I think when I sent it off to Muriel, did include, to be honest, I can't remember that it included that chapter. I'd left it out because by that point, I knew that Kate was writing her own thing on money laundering, which I still haven't seen. Although I think when I looked the other day, I did see that it was on the VLE, but there was no suggestion that it had been integrated. So, to be honest, I can't say whether if you've got a chapter 5 and it's talking about money laundering, the probability is the probability is it's my chapter, in which case I would just set it to one side. I think that's the expectation, that you'll be working off of Kate's section or sections. Well, I mean, I think I can't tell you clearly what the authorship is, but if it's anything that clearly is marked from Kate, my understanding is that you're to take that as the authoritative version. So, and I can't help you beyond that, really. Yeah. So no, I think, as I say, I was originally supposed to be writing a section on money laundering for the ethics study guide. The section that I provided, well, I'm not going to go through the history, but anyway, subsequently Kate said that she would be happy to take it on and write the relevant content for both this module and the criminal procedure module. So that's what happened. Although, as I say, I didn't have any inkling that that had been done and it was up on the VLE until this week. So there we are. So, but yeah, I would stick, if you can clearly identify something coming from Kate on money laundering, then I'd definitely stick with that. And that's what I'm sure she's going to be talking about in the course of tomorrow.
What do you see from Kate?
There's a separate study guide.
Is it this one?
That one, it's about 10 pages long. Yeah.
Yeah, but that's the.
That's not it.
Yeah.
That was sent out to me.
Yeah. So it's basically for our client, yeah.
Yeah.
Well, now we've got that's it.
Are we still on?
No, I've gone back to page 3 now. I'm on the table of contents. Right. You see the fun we've been having in civil last few weekends. Don't you wish you were doing that?
Yeah.
Yes, we are. Yes. Yeah. Yeah, we keep coming and going, but we're coming back again. I love page 7. It's my favourite. All right, so what else do we need to think about? Yes, your duty to provide all such information, like when you have been naughty or convicted of anything, or indeed accepted a caution for it. Provide that information within 28 days of a request to do so, and also notify any change of information within 28 days. So I think you've got to be prepared to be kind of proactive as far as that's concerned. So as it says, excuse me, the register is a public document, although certain entries may be restricted according to the Greffier's decision. And providing false information or failing to make the disclosure that is required of you will be a criminal offence. I didn't explore that any further in there. On page 8, I have to make the point that for some reason a word has been missed off of that, the last entry in that list. So the little I, to do all such things as are reasonably incidental or conducive to the attainment of those, rather teasingly, it just stopped at that point, but it should say objects. Yes. Yes, all right. Yeah, yeah. Yes, you make it your own. So, right, well, yeah. Anyway, thrillingly, you're on to page 8 now, which is great news. So, and there's only what 50 pages altogether, so we're whizzing through it. So, yes, RPC. So, as it says, the Bar Council itself is making the rules of professional conduct. Most recently, I believe, updated in 2015. You can see the process they go through there. To follow both within your professional practice and elsewhere as applicable. Okay, so as far as that's concerned, obviously a large number of the rules in the RPC will be very kind of context specific and related to your professional practice, but some of them will be a lot broader than that and kind of looking over your shoulder at all times. So yeah, you can't get away from them basically. Some of them, when you stop and leave the office for the day, yes, but others are still there, maybe in terms of what public's opinion of the Guernsey bar. So when you're whooping it up, I think wherever people go in Guernsey to do their whooping, yeah, then is it okay? Right. Well, okay. Yeah, I was going to say well, yeah, it sounded credible to me. You didn't even know it was shut. That's good. All right. Okay. Well, yeah. End of course party. I think that's definitely where we should go. We should reopen it, especially. All right. So RPC, as we can note from a case of involving Ogiers and Jeffries, which is mentioned somewhere in the study guide, page 17, I think. Not that you need to worry about that at this precise moment. But yeah, Ogier and Jeffries, one of the first things that one sees from the judgment there is the court saying that the rules of professional conduct are not binding on a court. So they are only, I guess, of persuasive or indicative value. So even if you've gone hammering through one or more of these rules, that of itself won't be determinative of any issue that's before the court, unless, of course, it's dealing with a disciplinary appeal, in which case, of course, they'll be very relevant. Okay. Yes, so implied term, the advocate has always to observe the rules of professional conduct, and therefore that sets up nicely the usual tension that one has in ethical practice between a number of potentially conflicting duties or obligations. So if you have to observe the rules of professional conduct, one of those rules says, for example, you will assist the court in the administration of justice, then clearly there may be instances where that flies in the face of some other obligations that you have, particularly obligations to the clients to act in their best interests. Then raises all sorts of issues around who gets to decide what's in the client's best interests. Is that for the client? Is that for you? Is it kind of paternalistic, objective? What's in? I'll do what I think is in your best interests. Thank you very much. Or do you have to defer to the client? Might be something to think about. It may, that sort of autonomy, if you like, or giving agency to the client, may be something that varies from one situation to the next. I'm not simply talking about situations where you have a vulnerable client, but any situation really. You know, some things are just kind of accepted, like, for example, whether or how to plea, how to enter a plea, what plea to enter for a criminal defendant. Yeah, very much, I think, commonly accepted that is entirely within the choice of the client to make that decision. And sometimes you may have experience of this yourselves, sometimes against the clear advice from their advocate to plead in the opposite direction. Yeah. But yeah, so as I say, there may well be issues there. We might also think another kind of hardy problem in this context would be things like disclosure or discovery obligations, where the client says, well, that's, if they find out about that, it's going to look very bad for me, isn't it? I mean, I really don't see me winning this case if we disclose that letter or pass out that email for inspection. And of course, you're saying, but we have that obligation to do that. I have an obligation to the court to do that. Yeah. And the client says, well, you may, but do I? I'm not sure that I do. So yes, this, as it says, an implied term within that contractual relationship that the advocate always has to observe the rules of professional conduct. And in a sense, that really is your kind of trump card, I would say, if there are kind of disagreements between you and the client in terms of what must be done or what must not be done. Or indeed, perhaps even to the extent of maybe your continued involvement in acting for the client, that you can simply say, well, it's a professional requirement. I have to abide by my professional conduct obligations, and that's actually a term within our agreement. Yeah. So I think it's kind of like I wouldn't say get out of jail free card, but it is a trump card. I think that gives you the final say on that matter. Next paragraph then. Part of your obligation to maintain your independence, not setting aside your professional judgment and deferring to the wishes simply of the client in an uncritical fashion. Yeah? So that is an element of independence, as well as one's obligations to the court if it's a piece of litigation. So as you can see, if the client insists on the advocate taking a course of action that would involve a breach of professional conduct, good reason for either ceasing to act or not accepting the instructions in the first place. Last point, I'm not sure to what extent we need to worry in this module about the employed advocate, but insofar as there is information about the employed advocate, I've done my best to include it. So as you can see, if you are an employed advocate, you're subject to exactly the same rules and professional obligations that would apply to one in private practice. And you can see the reference to the rules. It would be very time consuming for me to just keep zipping back and forth. I've set it up, as you can see, it's been sitting there for a few minutes now, Rule 84. So that's the next thing to have a look at them. You'll be chuffed to know, Laurent, that we're now on page 9. Yeah. So, yeah, well, we might be finished by lunchtime. No, we won't be finished by lunchtime. I don't want to raise false hopes.
Are we going to examine solicitors handbook and so on? How much do we need to know?
Well, I mean, it certainly can do. There will be cases, some of which are in here, where the court in Guernsey has made reference to authorities elsewhere. It seems to me there's slightly more of a tendency to refer to authorities from England and Wales that refer to the SRA and solicitors' problems rather than referring to the bar handbook. That might just be to do with the nature of the circumstances that led to the matter being before the court. So I think, what is it? The La Chambre de Discipline against an advocate from 2017. There was nothing litigious about that. It was an advocate who was acting for it wasn't Ben, it was Guarantor and Lendor, wasn't it? Lendor, yes. Because it was a spouse thing, wasn't it? To do with secured on family homes. Yeah. So yeah. So I mean that sort of thing. It's obviously much more sensible and relevant, I would have thought, to refer to the SRA handbook, because that's the nature of that relationship, really. But no, you're right. So I mean, I'm not going to sit here and say that, as well as the materials that you've got in the appendices in the study guide, that you need to demonstrate in the exam an encyclopedic knowledge of either the SRA handbook principles or the BSB core duties. I mean, I think in both instances, there's only 10 kind of core principles, and I think I've included both sets of 10 in the study guide. But beyond that, no. I mean, apart from anything else, so let's think about Rule 84. Rule 84 says when the rules are silent or ambiguous on a matter of conduct, so making the necessary changes so that they can apply. Let's look at the relevant rules and principles from, as it says, time to time, obliging English barristers and solicitors, which says basically look at the BSB handbook, look at the SRA handbook. I think I have tried to flag up in the study guide instances where I personally would have expected there to be something said, and there hasn't been something said. And that's when I've tended to then put something in from the SRA handbook or reflected on what the BSB would have to say on that point. But no, my expectation is not that you are being examined on the basis of two discrete professional codes, one of which clearly applies here, like the rules of professional conduct, and one of which is merely advisory or guidance or persuasive value. I mean, if you could pull any of that stuff in a situation where you think there is ambiguity or silence in the RPC, then so much the better for you. Probably get more marks if you can do that. Just a fact of life, basically. But of course, if it's a situation where the RPC are not silent and are not really, in the opinion of the marker or markers, ambiguous, then you're off on a bit of a wild goose chase. So, yeah, it's really, I mean, I think what I'm coming back to is putting it all on you guys and saying it's down to your understanding and your interpretation. If you are right and the RPC says nothing on a particular point, then yeah, it would make sense. If you could pull in something, I don't say it has to be one or the other, but pull in something as a kind of mirror holding up to sort of get a slight reflection of how we might approach that in this jurisdiction. But other than that, no, I don't think you need to know them. All right, yeah, that sort of petered out that sentence, didn't it, really? But yeah, I don't think you need to know them, full stop. Okay. All right, so, but as it says, you've got the relevant points in there. And yes, if I turn over to page 10, I'm not going to go through all of those. But I would say that, I was looking through these yesterday, the two lots of 10. And really, allowing for slight variations in wording and the things that some things have been maybe pushed together and other things have been pulled apart. The 10 SRA principles are almost coterminous with the core duties in the BSB handbook. I think the one clear distinction is Principle 10 in the SRA list, protect client money and assets, because of course the BSB approach to that is have nothing to do, run away screaming from client money. So clearly that's not the 10th principle as far as core duties are concerned. What I find slightly odd is core duty 6 must keep the affairs of each client confidential in the BSB list, doesn't feature at all in the SRA top 10 or big 10. So the protecting client money and assets, I fully understand why that's there. Even a nod towards confidentiality, I don't understand why that isn't there, but so be it. Yeah. Which is not to say, of course, that means that solicitors don't have an obligation of confidentiality. It's just not in those 10 main principles. All right, so jogging on then, onto page 11. Disciplinary proceedings. So yeah, as we saw, one of the things that the 2007 law said that the Guernsey Bar had responsibility for was disciplinary matters. So that's covered by part 2 of the law. So we have this framework. The body responsible is La Chambre de Discipline. I have been struggling mightily, I've said it several times now, I'm struggling mightily to avoid any reference to works of literature or film that it just reminds me of, almost irresistibly. but I've managed to avoid it so far. And having put it out there, I'm going to continue to resist it for as long as I can. It's tested my willpower. But I am very conscious. I'm helped by the knowledge that this is being recorded. So that's inducing a slight element of restraint that might not otherwise be there. Okay, so as we can see there then, we will look at it in more detail as we go along. Its proceedings are confidential. Generally speaking, as we can tell from the very few cases that have been reported, and probably very few cases that have gone through La Chambre in any shape or form, their overwhelming tendency is to sit in private, not least because obviously, again, there's a reputational damage issue there. It's kind of no smoke without fire. So even if proceedings don't go ahead, the fact that you've been the subject of a complaint may be some damage to. I mean, I don't know. It was something I was thinking about when I was reading through the July 18 judgment of the proceedings in the Royal Court. I'm thinking to myself, well, all right. So it says, well, confidential, held in private. Nice reasons for that. And I think to myself, well, I probably put a 5 on you guys knowing who that advocate is, but I'm not going to ask who it is. It doesn't matter to me who it is. But I just kind of think, well, it's probably a bit futile, really, isn't it? Saying these things are private and confidential, but hey ho. So anyway, at least in principle, they are confidential. And sorry, have I just encouraged an unauthorized disclosure? No. Of course not. No. So, as it says, obviously I wouldn't do that because unauthorized disclosure is an offence. So clearly that hasn't just happened anywhere in this route at all. But proceeds of crime, as is so often the case, form an exception. Because obviously, if you had to just respect confidentiality, then that may facilitate people maintaining the proceeds of crime, keeping the proceeds of crime, using them, etc. So as you can see, a relevant person is permitted to make a disclosure. And obviously, Kate will be looking at this in much more detail tomorrow. If they have been appointed to supervise compliance by a practicing lawyer with the POC regs. So disclosure of any information permitted where the relevant person reasonably believes it may help the organisation to do its job. I'm presuming that would be an entity like what, the GFSC? Assuming that's what it's still abbreviated to. Yeah, okay. So, yeah. I don't know, I'll leave that to Kate to be the authority on that. Well, I'm dumping this on you. Thank you very much. Well done. Yeah. Yes. All right. Okay. So, as it says there, follows if relevant information discovered in the course of disciplinary proceedings, no prohibition on any subsequent disclosure to a relevant organisation. I can see that I've thrown in an extra D on the end of course there, but that's just annoying me rather than you guys. Interesting one, employing advocates who've been disbarred or suspended. I mean, my personal view is that ever likely to happen? But I guess it could in certain situations. So again, I've missed out the whole word this time. Should say an advocate who wishes to employ a former advocate or one who's suspended has to seek permission, and you do that by applying to, as it says, the president of La Chambre to discipline, and that decision is subject to review by the Royal Court. No, I think it's just employed. Yeah, with it, yeah, but no, it's
no, it's if you went to were a receptionist.
If you wanted to work in a law firm, but not using a title advocate,
There's a chance to come back
to come back, yeah. Resurrection.
I can't believe it.
Yeah. So you're coming back as a receptionist. Right. Okay. So yes, page 12. So yes, 1.2. There are very few headings, but this is one of them. 1.2 standards and values. So we've already noticed from the screen there, an object from section 2 of the 2007 law is to maintain high standards of professional conduct. You can see then that Rule 1 takes that further because it talks about observing those ethical duties imposed on solicitors by the common law, and that's in the commentary. So again, to explain my kind of abbreviation, I'm sure you've cracked the code, but you can see in footnote 17 it says commentary to Rule 1, and I very rapidly got fed up with writing commentary. Although strange I didn't get fed up with writing law officers of the Crown. Anyway, yeah, so anytime you see like footnote 28 where it says see com 57.4, that's the commentary to Rule 57, paragraph 4. So com is commentary. Okay, very obvious, I know. So what else do we need to think about? Yes. To adhere to proper standards and maintain the good reputation of the Guernsey Bar, both the entirety of the Guernsey Bar and your own good reputation. And you can see I have drawn a parallel there with Core Duty 5 from the Bar's Code of Conduct. Must not behave in a way which is like to diminish trust and confidence which the public places in you or in the profession. So I think that's quite similar to that principle. And also from Principle 6 from the SRA Code, behave in a way that maintains the trust the public places in you and in the provision of legal services. So yeah, I think they're all pushing in basically the same direction. As it says, then sort of behaviour that crosses that line typically would be something that relates to your professional practice, and it might be something as banal as trying to fob off the court by having a pretend hospital appointment so that they don't list a case for a date that is inconvenient for you. As it says, it may be something that has happened in court. So you can see we've got some examples. I thought you'd enjoy these. English QC reprimanded and made to go on a training session for advocacy and the vulnerable as a result of making offensive and unnecessary remarks during submissions to the Court of Appeal. No, I didn't footnote, no, but I did give you the name and the date of the tribunal finding. So I thought that was as far down the disclosure route as I was disposed. Otherwise, just become kind of like sensationalist news of the world type of stuff. And I've already explained I need to restrain myself in this sort of thing. Yeah. So that's as far as I'm going with that. As it says, something in your personal life, though, that is also covered. So maybe driving under the influence. And again, you've got an example of that. An offensive dishonesty, almost inconceivable to me. I mean, this frankly doesn't happen that I can think of an example. I hardly think of any examples. I can think of one or two. But clearly, stealing, being convicted for stealing would be an obvious no-no. Convicted for being involved in the supply of controlled drugs, guaranteed to breach, and you've got a couple of cases there. I mean, it's hard to say how far down the road this goes. There is a case which I know about from Jersey, where a Jersey advocate was basically, I'd say, involved in a very, very minor and only like one or maximum two occasions, instances of social supply, very, very small amounts. And as far as one can see, reading between the lines, really just kind of picking up the housekeeping from a boyfriend that was a bit kind of slack, and, you know, he was kind of making promises to mates to do things and then saying, oh, you know, can you sort that out with, you know, Big Ron or whatever, I'm a bit busy at the moment, love. So she picks up one or two things like that and got convicted for being involved in the supply of illicit substances. And one might have thought, and indeed I think the report suggests that she really should have been struck off, disbarred, whatever, I can't remember what the precise term is, but removed from the role of Jersey advocates. But I think they did take the view that it was a very, very minor instance of being involved in supply of drugs, and it wasn't really her that was the prime mover, so he finished up suspending that disbarment. But generally speaking, it's not a good thing to be publicly involved in that. There's a case of, I don't think it ever went to a disciplinary matter because it almost didn't need to. There was a pupil in the set of London Chambers who was queuing up with his mates to get into a nightclub. Obviously not that one because it was in London. Yeah, right. Thank you. Sorry, I've noted it. Don't worry. That's the warm-up act, is it? Yeah. What you whistle, yeah. Okay. Right. Okay. Yes. Where was it? Oh, yeah. So queuing up to go into a club. He wasn't queuing up to go to a nightclub. He was queuing up to go into a club. Yeah. Anyway, so he was stopped and searched in the queue, and I think a little kind of baggie of coke was found tucked into his sock, fairly self-evidently for personal consumption, I would assume. But anyway, so he got pinched for that, and that did not go down well with Chambers, where I believe his pupillage was rather abruptly concluded, never to be continued. Notwithstanding, I think that I think he was the son of a senior member of Chambers, so that's a bit unfortunate, isn't it? Unfortunate for everybody concerned, really. So yeah, drugs. I don't know. I haven't followed his career. I think he might be working in a club. Yes. Anyway, I don't know. So what else do we have there? Oh yes. Don't even need to be practicing as a lawyer to fall foul. So I'm registered English barrister. So that's one without a current practicing certificate. You guys don't have practicing certificates, do you? That have to be renewed annually? No. So you don't actually have that kind of annual moment of truth, as it were. No. So once you have to take the oath.
Yeah, you have a.
Do you? What, like a DBS thing? Yeah. Okay. Well, annually. Oh, okay. Oh, after that, it's home free.
Yeah, but that's the
Yeah.
choice. You don't have to. So you get three membership. I choose to take the class rather than being an obligation. If I wanted to become a member of the ABA or something, then I can switch that membership, the member classes, or something like that. You don't have to keep it.
Does it offer any practical advantages, though?
No, I keep mine. I still do stuff.
Okay. Yeah. Right. Because you need it. Yeah.
I need it, but I wouldn't take it. So
Yeah.
no obligation.
No. Okay. All right. Yes. Okay. So, what else do we need to think about? I think the rest of that page is self-explanatory. Something else I think we do need to flag up is kind of more collective responsibility. So you're not merely responsible for yourself, but you are responsible for the acts and omissions of your firm and those who work for it, presumably even down to the reception staff. Yeah. So proper supervision is one of your professional requirements. Advocate not to abuse his position as such, and an example of that, general example, might be misleading the court. Abusing your position might also be calling false evidence. That would be an abuse of your position as an advocate. This would be in kind of court-based work. Making serious allegations against witnesses you don't have any evidential basis for, that might be considered to be abusing your position as an advocate. Okay, so acting with independence and honesty in professional dealings, again fairly self-evident. Should be courteous, always acting within the law, not advising the client to do anything that would involve breaking the law. A nice contemporary parallel, I guess, with what's his name, Michael Cohen in New York, and his presumably now former client, person number one.
Yeah.
Yeah. Okay, good. So, yes, not advising actions which result in breaking the law, like what, covert payments of hundreds and odd $1,000s to somebody for something that never happened in the first place. I mean, there are shades. I guess it just occurred to me. There's shades of Jeffrey Archer in there, aren't there? Really, handing over a brown paper bag of cash for no reason at all, really. Yes. But very much like Laurent's receptionist, he has risen. He has risen. Yeah, good. All right. So, oh yes, appearance. This is something we touched on. I think I've got Mark to talk about this, didn't I, last weekend, about apparel. And I have to say that I didn't make any note of what he said. I knew it was being recorded. So if you want the full info on that, then perhaps, yeah, have a look at last Saturday's recording from Civil Procedure. It's in there somewhere. But as you can see, yes, when appropriate, wear the proper robes. That's a sort of bland, tells you nothing statement that I love. Who wrote that? What a waste of time. Anyway, yes. Wow. Oh, okay.
That's not clear to me. Let's say you got
Mm-hmm. Right. You're asking me a robe question. Okay. Never? Never? I think you sleep in it, don't you?
You take it off the way. And it's
you're waiting around. This is what I think.
What you mean?
No, but if you wait, let's say you're waiting.
Yeah. And then when the judge sends the quickly pop it back on.
Just do it.
Unless you're the only one in court.
Yeah.
There is one court system.
Maybe we could ask, Jessica's coming this afternoon, maybe we could ask her. Yeah. Yeah.
After 4 weekends of classes,
Yeah. Presume you don't wear it at a jaunty angle.
Wow.
That's the only reason I'm getting
Yeah. Okay. Good. Right. So, wow, page 13. Time just flying past, isn't it? So, advocate under duty reports serious misconduct of fellow advocates. And you can see that is Rule 73. Interestingly, the rules don't tell you who you should be reporting that to. I'm assuming that it's going to go to the president of La Chambre. That's what the Royal Court website says, and I'm the last person to disagree with the Royal Court website. So there you go. All right, advocate in the court 1.3, page 14. So we cannot deny that there is a duty owed to the court, and that's back in the big one, Rule 1. It says reflected, I think it's reflected in lots of different rules, but I've picked one out there. Rule 20, we haven't looked at that yet. So advocate must not take action which he believes is motivated only by malice or vindictiveness on the client's part. So this is, and I think it's a difficult one to judge, isn't it, really? But it does say motivated only by, so maybe that's a kind of saving grace, that as long as you think that there is some other basis, maybe ancillary basis for it, but there's a legitimate grievance, claim, upset, whatever it is, then you can still go ahead, even though it does seem that, I mean, if you feel that you've been wronged, if I feel like I'm the victim of fraud, then I'm going to fraud, and I'm going to be feeling rather vindictive towards the con artist that I consider has ripped me off, stolen all my pension contributions. So there you go. But all right, so motivated only by, I think the only is the key word there. Yeah. So if it just seems like some kind of punitive sanction. Okay. So we've already thought about the oath and the articles under the oath, so I'm not going to say any more about that. We have flagged up already want between the duty owed to the court and that owed to the client, i.e. duty to act in the client's best interests. Do you want to look at commentary to 23.2? That might be an idea at this point. I can scroll back through to that. Yeah, I mean, it doesn't, having got there, it doesn't really add a great deal to the sum of human knowledge. Advocate owes the duty to the court, which must be reconciled with the duty of the client. So literally, that's all it says. I think there might be more interesting than that, but there you go. So, as it says then, in terms of the obligation to the court, has to be enabled to make a legally valid decision. Again, this is fairly standard ethical principles. Legally valid decision, and the next paragraph goes on to make a distinction with a factually valid decision. So let's deal with the law first. So the law, should we say, tends to be normative, it tends to be objective. That's how it works. It applies to either everyone or those within a particular category or class of individuals as defined by the law. So the court has to make a legally valid decision, and it's your job as officers of the court to ensure that the court is given the correct legal matrix within which to reach its decision. Now, obviously, we're only human. We won't necessarily remember every single case that might be relevant. Our legal research skills might not be, up to A++ standard, but you do your best. That's the basic point. You do your best. You try to be as up to date as you can. Obviously, these days with the internet and Google, there's far less excuse for being out of date than there was when I was your age, when pretty much everything was still kind of paper based. Used to be a thing called current law. Does that still exist even? Current law? But used to like a monthly installment of everything that had happened legally, which we used to which we used to await eagerly. Yeah, getting ahead of myself now. But no, I think that's gone now, so you're on your own. Obviously, there's like current awareness that you can have a look at, but yeah, then you're reliant on somebody else's algorithms or research or linking things together. But yeah, the court's going to be far less forgiving of ignorance of the law. So, court must be informed of all relevant legal principles, as it says there, even if doing that seems to be aiding the enemy. And again, the client may struggle to see how that's a good idea or in their interests, but that, I'm afraid, is the way that it has to be. As I have noted, the kind of saving grace there really is, frankly, if you are aware of a legal principle that is terminal to your arguments or your client's cause, then you shouldn't be advancing the cause, because it's going to be a bad cause, in the words of the articles to the oath. So you shouldn't have started it, or having started it erroneously, you should now be stopping it. So the very fact that you aren't taking either of those courses of action would seem to suggest that you have found some way to distinguish that legal principle, somehow. Maybe even suggesting that it should be appealed against. We'll have to take this case up to a higher court to overrule that legal principle or that precedent, and this is just a kind of necessary step to get up to that higher level. So there might be that. So as I say, if there is an opposing principle, either you've got to have some way of distinguishing it and saying how it's not fatal to your case, or accept that it is fatal and that's the end of it. The case has come to an end. Anyway, that's the law. As far as the facts are concerned, then facts are very much a kind of partisan matter, yeah, because it's all to do with the evidence, which is not objective, yeah, not laid down by anybody, so it's case specific, and it just depends. Since we're in an adversarial system, it depends on the evidence that the parties both have available and wish to adduce to support their case or to undermine the opposing case. Yeah? Also, of course, within a slight legal context, because you need to be clear on the rules of admissibility, what you can and cannot adduce. But the fact of the matter is, as it says there, unless you're appearing as a prosecutor in a criminal matter, you're under no obligation to inform either the opponent or the court of the existence of facts or a witness who would assist the opposing case and thereby harming your own case. All right. Obviously, it's different if you're calling what you know to be false evidence. That's a massive prof con problem. But you don't. There's no requirement to produce all information, generally speaking, to a court in litigation. You have autonomy over who you call, what questions you ask them. Obviously, the court can ask their own questions, but what questions you ask them. So, to that extent, it's entirely up to you what evidence is produced. And I would say something we certainly say on the bar course back home is that you're under no obligation to assist an incompetent opponent, essentially, certainly as far as facts are concerned. Legally, yes, you do need to make sure the court has all the material before it, but factually, you don't need to assist an incompetent opponent. And the same goes, obviously, if you're confronted by a litigant in person. Yeah. So, you know, there may be slightly more obligation to make sure that you're citing all of the legal principles, because they're probably not capable of finding them. But factually, you don't need to do their job for them at all. Yeah, okay. So something else to think about. Yeah, so the calling of false evidence, as it says, they're clearly unprofessional conduct. However, if it's simply your opinion that this witness is a dodgy witness and you've got nothing at all to substantiate that, then that's really of no interest to anybody, what you happen to think about the veracity or reliability of any given witness. So there's a distinction to draw there. So as we can see towards the bottom of page 14, the RPC says this: you have no duty to ask your client if they are being truthful, and that's whether they're making statements to the court or through the pleadings that are being tendered on their behalf, or in affidavits that presumably they or their witnesses are deposing to. All right. On the other hand, there is case law, which would appear to be Massoud and Zahur, but also, I think, referenced in Ogier and Jeffries, that an advocate has an obligation not to make factual submissions unless he has personally checked, as far as is practicable, that those submissions are based on the truth. Yeah? Affidavits, so far as is practicable, should contain only true and complete factual statements. So that's like what? I swear to tell the truth, the whole truth, and nothing but the truth. Yeah. Not sufficient to rely on lawyers and other jurisdictions to have done the checking. I mean, that's a pretty kind of arcane point. I would have thought myself, but I've thrown it in because that was the defence, or possibly the plea mitigation used in the Massoud and Zahur case. Yeah, not us, Gov. It was him over there. Yeah, across the sea. Don't blame me. And of course, said, well, we are blaming you because you're standing here in front of us. So that's not getting you anywhere. Yes.
How many times have we cover up the
Well,
so if you integrate some of that into your own,
yeah. it's a tricky one. Yeah, it is tricky, and obviously that's exactly the sort of thing that happens in real life. And it's, you know, what can I say? 99 times out of 100, there's no problem. Nobody makes a fuss about it. There's no consequences. Yeah, so no harm, no foul. But you know, there will be an occasion where there is a consequence to that. So I mean, it does only say as far as is practicable. So you don't have to go to the ends of the earth, check these things out. And, you know, there will be obvious finite limits on what you can do and the steps that you're required to take. But you know, all I think it's really saying, all I'm trying to really say with that is exercise a little bit of caution, just in your own interests. Really. Never mind the client, just in your interests. I mean, you know, it's no fun having your knuckles wrapped. Told, you know, you shouldn't have done that. So
it's also a matter of phrasing. I mean, people probably would say, evidence in the documents and stuff. I am informed by Mr. X that this is what happened, and that's your or as Mr. X states in his affidavit, whatever. Yeah. And again, then you're not saying, you're not really making a claim on the truth. Yeah, then that's the truth is that's what you said. So,
Yeah.
that's what we like in ethics, wishy-washy. Yeah. Right. Well, it is the Panto season at the moment, so it's very, very apt. Yeah. All right. So now, next, the shocking scenario that, in my experience, very seldom presents itself. Client admits to their advocate that they have misled the court in the current proceedings through giving perjured evidence on their oath or otherwise. Have we ever had an example of that we've had to draw attention to? No? No? Not that we're prepared to disclose in this room anyway, knowing that it's being recorded. But anyway, I'm sure there's no kind of voice recognition ID software that could pick up anybody's specific contributions this afternoon. All right. But as it says there, you have no choice but to cease to act. Only exception to that is if the client agrees to disclose their falsehood and put the true position before the court. Now, I don't know about you guys, but I do get students. Obviously, my students tend to be, no disrespect intended, but younger, because they've just come off the back of their first degree. And they've really not got much experience of life, certainly not the sort of experience that you guys have of dealing with real life clients. And they seem to be quite concerned that, I guess my approach to this is somewhat more, I don't know, cynical. And they say, well, you know, you just ask your client if they're telling the truth. I say, no, I've never asked a client whether they're telling the truth or not. In fact, you know, frankly, on the one occasion when one of them offered to tell me the truth, I made a colossal error by saying yes. Well, that was a lesson learned. Not that I needed to learn it, but it was just a reminder. I need to be slightly more alert. I mean, to be fair to me, we were sitting in a very stuffy, airless, natural, lightless vestibule in the delightful environs of Barking Magistrates Court. And we'd been there for about an hour and a half, waiting for the court to finish whatever it was currently doing so that we could start the summary trial. And I was with a couple of defendants who I can only describe as like the main protagonists from Of Mice and Men. And the Lenny character, we'd been there for about an hour and a half. We'd exhausted our social conversation in the first 5 minutes. So we'd just been sitting there staring at the floor. And yeah, so eventually Lenny said to me, "Do you want to know what really happened?" And I just completely tuned out. I'd gone to my happy place. And so I must have said yes. And so he told me what really happened. And I said, well, so are you going to change your pleas to guilty? And they both looked at me and went, no. Why would you do that? I said, well, because you just told me that you did it. Yeah, and, you know, everything we tell you is confidential, isn't it? Well, there are limitations on that. So anyway, so then, of course, the realization, I mean, it was kind of good news, bad news, because I realized that I could now withdraw from representing them and I didn't have to do the summary trial. So that was good news. But I also realised that I still had to sit around waiting for the other bloody proceedings to finish so that I could go in there and effect my withdrawal. So that was the bad news, really. What, my withdrawal? Well, I mean, how are they going to take it? I mean, the fact is that it's been listed for summary trial. I walk in, say, right, I am no longer representing the defendants. I'm professionally embarrassed and have to withdraw. I mean, you might as well run a big flag up the flagpole outside the building. So guess what? Yeah. So anyway, there we are.
That's the issue.
What, doing the right thing? Or being stupid?
I meant it's like we talk about the young people.
Yeah. Mm.
And this kind of question about don't ask, don't tell.
Yeah.
Without that, advocacy wouldn't work. That's what I say. I mean what I said. It's like everything turns around this little kind of.
Well, does it?
I think so, yeah.
What?
I think, and this is that's the whole. I mean, that's kind of the whole point.
Well, yeah.
Yeah, and I think.
Well, no, but I mean, no, you can hear. Well, I say you can hear. I think you can hear. You certainly can in England. No, you can't run a positive defence. That's the point. You can't run a positive defence, but you're still entitled to put the prosecution to proof. Yeah, so you can definitely do that. And again, see, that's something that maybe the public would struggle to get their heads around. But then you start talking about the burden of proof, presumption of innocence, then they might begin to get a bit of an inkling about what's going on there. But it's like the classic, as like we're so often told, dinner party question. I mean, I don't go to dinner parties, so people don't ask me this question. I don't. It's something like I don't go to them for that reason, but that's not how that works. But how can you represent someone that you know, or when you know that they're guilty? Yeah. Of course, one of the answers to that is, well, if I don't know, first of all, your question presupposes that I know that they're guilty. What I think you're referring to is a situation where I think they're guilty, where the evidence is overwhelming against them. It's like, well, let's look at this CCTV, shall we, and see who we recognise from watching this CCTV. Right, CCTV client. Yes, it's looking a lot like you, actually, in my personal opinion. But what do you say about that? Yeah, it's not me. Okay, right, I'll make a note of that then. Not the client. Okay, good, excellent. So moving on then. Whatever I think, nobody cares. Nobody cares about that. But if I do know, the only way that I can know, or two ways that I can know. One is that I am a witness to it, and that's how I know. In which case, I shouldn't be the advocate. Or the other way that I know is because the client has told me that. So that's the only time that I'm going to know that they are guilty. But even then, I can still say, well, I can represent you putting the prosecution to proof. I can test their evidence. I can't run a positive defence like your alibi defence, for example. And the client either swallows that and goes along with it, or might say, well, so what are the chances of getting a not guilty? If you're just going to test the prosecution and go, well, not as high as they were with your alibi defence, but that's a non-starter, that's dead in the water. They go, well, why is it? Well, because you told me that you've done it. Okay. Oh yeah. Yeah. Because it's a bit of a lost leader if you go in there and plead guilty and then say, but we'd like to have a trial where we can test prosecution evidence. That's not gonna run. So you go in there and plead not guilty because there's a burden of proof, and your client can tell you they are guilty of the most heinous offence, and if the prosecution haven't got the evidence to make it stand up, then we're walking out with a not guilty verdict. That's how the system works.
When you've got like a rule that says unless you're prosecution, you don't have to tell anyone else about any witnesses or any facts or anything like that. Is there then an interplay with the overarching duty to humanity that say you're representing
a murderer who knows that there's a child sitting in a cage
Mhm.
somewhere about to be consumed by water.
That's fine.
Yeah. Yeah.
Right.
No, I think this is one of the darker Harry Potter films, if memory serves me correctly. Yeah. Yeah. Yeah.
You, does that comment like that? Is that just one of those we like?
No. Well, there is an exception. Basically, what we might summarise as child protection to breach client confidentiality, or as required by law. So I think if you're aware, I mean, you'll see this elsewhere in the study guide, but if you're aware that there's a serious offence that is going to be committed or is indeed in the course of commission, I mean, even frankly, arguably has been committed, and you are now aware, perhaps, I don't know, of where the body is buried, yeah, so that it could be repatriated, that type of thing, then I think most people would understand that that is a legitimate exception to protecting client confidentiality. Yeah. Okay. Yeah. All right. So, what happens if the client changes their account? That's always an interesting one. Their account tells you a different story. Yeah. So yeah, sorry, not financial account or anything like that, but yeah, changes their story. Yeah. As it says, if they're making inconsistent statements of itself, I don't think that either entitles you or requires you to withdraw from acting for them. As it says, and somewhat in contradiction to what I was just saying, it says, plainly the advocate will want to know what is the true account. I mean, I don't think you'd ever put it that way, really. I think you just say that you want to be clear on what your instructions are. You know? So I think you do need to kind of nail that down. And as it says, if the client gives you an acceptable answer, you can carry on and present the account that you've been assured by them is the one that they're running with. So there you go with that. All right. False evidence. Well, it's not really false evidence. Well, I suppose it might shade into that. Rule 78 prohibits the advocate from making or offering a payment to a witness that is contingent on the nature of the evidence given or on the outcome of the proceedings. Now, obviously, yeah, you can pay witnesses their expenses. They shouldn't be out of pocket for attending and providing the information in the proceedings, but that's about as far as that goes. So no sort of contingent payment. The tendency, I suppose, is to think about this in the context of expert witnesses. Expert witnesses, certainly if they are towards the more kind of hired gun end of the expert witness spectrum, might be expecting, they might be demanding some kind of success fee, or they might be prepared to keep their upfront, they might sound like a cheap deal, and keep their upfront fees very low so that you hire them on the expectation that if the right result comes in, then everybody's quids in. Yeah? So there might be some kind of suggestion of a contingency there, but that would clearly be flying in the face of Rule 78, so not to be done. Advocate has to conduct him or herself with courtesy towards others in court, not making an allegation that is merely scandalous, nor one that is meant solely to insult, humiliate, or annoy. And again, these are important kind of limitations or caveats in here. So merely is a key word there, like solely is as well. So it's a bit like that point about what? Motivated by malice or vindictiveness, same sort of idea really. So if you've got a merely example, I'll give you the example that I normally trot out at this point is prosecution of the Grillo sisters, who you may or may not recollect ever reading about, but you will have read about them because they were the defendants in a case that involved fraudulent misuse of the credit cards of Nigella Lawson and her then husband, Charles Saatchi. Yeah? So they were prosecuted for racking up thousands of pounds of, according to the prosecution, dishonest payments, paid for holidays, paid for jewellery, paid for all sorts. sorts of things for their own benefit. Do you remember what their defence was? Now that I've reminded you of the case. Defence was that this was not dishonest use of the family credit cards. It was permitted use. We were allowed to rack up these expenses, which obviously prompts the question, why? Why on earth would that be? And they said, well, because we knew about Nigella's use of certain classified drugs, cocaine, and we also knew that possibly less problematically, that she was letting the children of the family smoke cigarettes. And I think that was just cigarettes, nothing fancier than that. But it would have upset her husband had he known that. So we agreed to keep stum on both her drug habit and her permission to the kids to smoke. And in return for that, she let us have free reign on the family credit cards. Yeah. Now, that was their defence. And obviously then, in order to back up that defence, it wasn't enough for the two of them to go into the witness box and say that, although I think, if memory serves me correctly, they did. Obviously, the prosecution tried to preempt that and show it up for the nonsense that it was by calling Nigella Lawson. No point in calling Charles Saatchi. I think they did call Charles Saatchi for other kind of more formal evidence. But calling Nigella Lawson to explain how she didn't do any of those things and agree to the sisters' use of the family credit cards. So she was in the witness box for, I think, the best part of 3 days, being cross-examined. She said it was worse than being on trial herself, which is, of course, quite an it's not an unusual thing for people that have been cross-examined, particularly in the criminal court, to feel. If there's any kind of assertion or challenge to be made against them. So, so she was cross-examined for, say, the best part of 3 days, which is not a nice experience for anybody to go through. And of course, the media lapped it up. Although, yes, no reference to cocaine there at all. So, yeah, they made full play. It was on the front pages of national newspapers and so on. The judge didn't stop that line of cross-examination because it was a core part of the defendant's explanation. Yeah, it's a core part of their defence. And, of course, it ended up with their acquittal. So, clearly the jury probably went along with that, or found the prosecution hadn't proved their case for other reasons, but I suspect went along with that idea. And I believe that Nigella indeed suffered some adverse consequences when she had her visa denied to the US, because they're a bit hot on letting cokeheads, so people that use illicit drugs, coming in to make TV programs and such like. So yeah, but that was all okay. Just to say, don't ask this woman any questions. The judge allowed that to go on, and that's because the suggestions that were being made were A, it appears truthful, but B, and this is much more important, not merely scandalous and not solely humiliating or annoying to the witness to be asked. They were a core part of the defendant's case, and those questions had to be asked. So as I say, those are the key words there, merely or solely. If there's a legitimate, relevant purpose, then you're okay. Right. What's our next thing? Oh, yes. Lay courts. All right, lay courts. So obviously the Court of Alderney or the Court of the Seneschal are manned, staffed by people who are not themselves qualified as lawyers. So they are very much dependent on the advocates who appear in front of them. And as you can see then, you've got cases like Leopard from 1993, where it is said that the advocate then has a special duty as a Minister of Justice. I think it's an interesting consideration to what extent, therefore, bearing in mind we were just looking on the preceding page, page 14, about the necessity of enabling the court to make a legally valid determination on whatever the issue or issues are. what else this is asking you to do, to be perfectly honest. Again, the point is that, yes, you have to put all of the relevant law that you're aware of before the court. That applies whether you're up against a litigant in person or the most senior advocate in the island. There's no distinction to draw as far as that's concerned. But maybe you just have to be a bit more, I don't know, accessible. I don't know. I find it hard to see what the distinction is there. Seneschal was relying on counsel to assist him. Also, earlier comments from Sir David Carey. When counsel appears in the lay court, they bear a very special responsibility. I mean, you can kind of see from that quote, maybe some of the points there. Counsel need to work together to identify the issues. But I mean, that's what pleadings do, don't they? Anyway, do all they can to prepare and present the case in a way that he can come to a reasonable decision. Well, you know, that's what you do, isn't it? But apparently not. You can see their deputy bailiff in the Carteret case felt that hadn't happened in those proceedings. The pleadings were, well, you know, it doesn't sound very good, I must admit. Pleadings were inadequate. Defence hadn't been filed. Nothing suggests the advocates had collaborated to identify the issues that the Seneschal had to determine. So it doesn't sound like the best prepared case that one's ever come across. Surely those criticisms should have been made anyway. So I don't know. Maybe again, Jessica can shed some light on that this afternoon. All right, next paragraph, not having private chit-chats with the judge. So as you can see, if you're an advocate with a case before a judge, whether it's currently being heard in court or not, then you should not be having discussions with the judge about that. You can see exception where the court invites the advocate to engage in a conversation and the opponent is present or somehow otherwise represented in court. So discussions should not be initiated by the advocate. You may, I mean, I don't know. You may feel the need to initiate a discussion. Yeah. I think the point here really is, because it says extracurricular discussions, these would be maybe, I don't know if, I mean, you guys would stand much more chance of running into a judge who's handling a case that's proceeding than I would ever in practice in England and Wales, unless I was living somewhere very back and beyond, or Woking, perhaps. If I was living in Woking, massive population density of High Court judges down there. Yes, they all come up on the judge train in the morning. Anyway, up to Waterloo. Anyway, never mind. So yeah, do not initiate discussions. So I don't know, at the golf club, 19th hole, that type of thing. I mean, you can talk about all sorts of things, like your handicap, yeah, that type of thing. Who should be the next captain of the Ryder Cup team, stuff like that, but not about the case that is currently working its way through the system. If you do find a need to go and see a judge about a case, then I would say that can only ever happen in a very formal way, and as it says there, should happen on a kind of bipartisan. Natural justice requires hear both sides. So always inform the opponent. Try to take the opponent along with you. Try also possibly. You guys don't have stenographers or shorthand writers in court, do you? Everything's just recorded. Yeah. Yeah, but I mean, if you wanted to see the judge maybe in the judge's chambers, you'd have to make some kind of special, or take someone along, maybe as an associate or something like that, to take a note, to record it. Yeah. And probably be prudent thereafter to make sure that everybody signs off on that note. Avoid any consequences down the line.
Usually, it happens that the judge both sides.
Yeah. No, all right. Mano a mano with the judge. Yeah. Yeah. Well, I mean, well, it's happened. No, it hasn't happened to me. It could have happened to me. As an example, then, I was doing a case in the Crown Court. I know it's different. You don't have jury trial. But I was doing a case in the Crown Court, and we managed to struggle as far as lunchtime on day one. And my client had been on bail throughout the proceedings up until this point. And so the jury, we broke for lunch. The jury were filing out the court, and I just stood up and said, Your Honour, I make the usual application, which I think we all understood was code for he's been on bail throughout proceedings. Can he have bail, over lunch and overnight, at least until we get to the summing up, please? And the judge just kind of looked at me and went, no, it's denied. And stood up, walked out of court, slammed the door behind him, and that was that. What just happened here? So anyway, to cut a long story short, I spoke to the clerk. The clerk said to me, he never grants defendants bail over lunch. Right? So I then had to explain to my client that this wasn't some kind of personal attack or slight, either against me or against the client, but that he was going to have to go down to the cells and enjoy a wonderful bowl of soup on the taxpayer. He didn't seem that fussed about it, to be fair to him, but I wasn't very happy. Anyway, so obviously I said, when the clerk said he denies everybody bail, I just didn't leave it at that. I said, well, why is that then? What possible justification? And the clerk said, well, this is a very small location of the Crown Court. There's only one canteen, probably isn't even a canteen at all there now, but in those days there was. There's only one canteen for everybody in the building to use. So that's where the jurors will go to have their lunch. And, we can't guarantee that if the defendant is sitting at an adjacent table, that either the jurors won't overhear a conversation that they shouldn't be overhearing, or that maybe some of them may not feel that they're being kind of eyeballed by the defendant, etc., etc. So it's just his policy. Nobody gets bail over lunch. End of story. So anyway, I wasn't very happy with that. So we managed to get to lunch on day 2, and we basically ran through the same again. I had the usual. I didn't even get, I think, to the end of application to make. I think I managed to say I have the usual, and then the door slammed. Just kind of whoosh. As he left the courtroom, the door just slammed. So I'm not having this. As it happens, I was being prosecuted by somebody else in chambers. So I said, well, I'm going to try and see the judge in chambers. You're going to come along with me. So I think he thought it was going to be fantastic watching my head being ripped off before his very eyes. So he said, yeah, I'll come along with you. So we took the shorthand writer, of whom there was one in those days, took the shorthand writer with us. The clerk came along, because obviously once you'd gone through that door at the back, well, you guys probably know it intimately, like behind the scenes, it's like going backstage at theatre. You don't know where the hell, because you've never been there. So you need a guide, you need a native guide, which was the clerk of the court. So the clerk, guided us down all these crappy corridors. I mean, I don't know why you want to be a judge. Moth-eaten carpet, wallpaper falling off the walls, disgusting. Anyway, so we got. Anyway, I'm making a big meal out of this, but we got to the judge's chambers, and the clerk knocked on the door and just kind of gently eased it open. The judge didn't even say come in. He was just standing there, still robed, puce, like he was about to have a heart attack. Just literally on the other side of the door. So anyway, we managed to get in. I made an application. The prosecutor did not oppose it. The judge couldn't have cared less about the prosecution. The judge just refused or re-refused bail, and that was it. And my client was by that time enjoying his minestrone down in the basement. And day 2 passed. Day 3, I was all set to go in a taxi to the divisional court to apply for a writ of habeas corpus, which I thought would be fun. And unfortunately, we never got to lunch on day 3, so that one fizzled out. But so that was me initiating an approach to the judge. So I think there may be times where you do feel the need to do that, but you should be trying to make it even-handed and make sure that everybody's represented. And it's recorded.
I'm just saying that you.
Yeah. Well, yeah. Okay. So, no, I had an excellent track record in the Crown Court. Juries loved me. Yeah. All good. Yeah. No, we won that one. Yeah. That's fine. Yeah. Yeah. Obviously, the jury had no idea of what was going on. They were just enjoying their minestrone or soup or sandwich, whatever it was they were having somewhere else. But, yeah. No, I mean, I actually suggested when I went in to see the judge, I said, I appreciate your concerns for the jurors. I said, but I've spoken to my instructing solicitor, and I can give you an undertaking on behalf of my instructing solicitor that this lunchtime and every subsequent lunchtime, my instructing solicitor will escort my client off of the premises, take them to a nearby cafe or restaurant, remain there with them, seated at the same table, and have lunch with them, and then escort them back to the court building. Yeah, how's that for a solution? So he just wasn't having it. There we are. Right. What was that? All very quiet. Yeah. Right. Where are we? 10 to. All right. Should we just do the next paragraph? No property in a witness. Yeah. So that's quite an interesting one. I mean, it's obviously something that is quite often trotted out, that there's no property in a witness, but Rule 77 pretty much spells that out then. As you can see, then, permissible for an advocate acting for any party to interview and take statements from any witness or prospective witness at any stage of the proceedings, regardless of whether that person has been interviewed or even has been called as a witness by another party. So that's about as broad a permission as you could possibly hope to get in that sort of context. However, obviously, there is the potential for either tampering or the appearance of tampering to go on there. So the commentary unpacks that a bit more. As it says, the advocate may well be exposed to the suggestion that he or she has improperly tampered with the evidence, particularly, surprisingly, where the witness subsequently changes that evidence. Yeah, they were saying A all the time up until they had that conversation with you. Now they're saying B. Yeah, so it's kind of what is it? What's the word I'm looking for? Cause and effect, causality. So not. Yeah, all right, never mind. Okay. So, as you can see then, this is coming back to making sure that everybody's present. Good idea to offer to interview the witness in the presence of a representative of the other side. Of course, you may feel that rather kind of kills off the likelihood of them being candid with you if they've got, like, member of the other side police present in the room, but that may be the price that you've got to pay to get access to them. Anybody ever interviewed the other side's witness? Heard of it being done? No, I don't think it's something that happens, frankly, very often in reality, because it's such a weird situation, isn't it, really? I mean, I suppose you might, if you had a witness, if you were in a trial where the other side had a witness that turned hostile, you might want to do it there. Yeah. If they kind of decant effectively to your side of the proceedings, you might think, oh, hello. Might be a good idea to interview them, take a statement. Aside from that, I can't see the point, really. As it says, proper course in a criminal matter where we have the defence, because, of course, defence lawyers in crime are never to be trusted, particularly with prosecution witnesses. So the appropriate course there is to get in touch with the law officers and arrange for the interview to take place either in the presence of a law officer, just to kind of slightly ramp up the intimidation of the witness, just to stick to their original account, or a Crown advocate or an appropriate police or customs officer, no doubt in full uniform. So that is the way to do that. I'll just do the little bit on advocates and witnesses, and then we'll adjourn for lunch then. So moving on to page 17, as you can see, the rules of the professional conduct don't encourage advocates to also ride a second horse in proceedings and become a witness as well. So the paragraph goes on to explain why that's not a great idea. But you can also see there the paragraph investigates the idea that you may not actually be a very good advocate or appear to be a very good advocate, not if you're the witness. I mean, that is quite a challenge in its own right. But if the witness is another member of your firm. So Rule 79 specifically picks this point up. Advocates shouldn't accept instructions to act, and presumably, one would imagine, should return those instructions or cease to act for the client where it becomes obvious that you are going to have to do this. But yes, cease to act where he or another member of his firm will be called as a witness for the client. Yeah, so don't be an advocate and a witness yourself. Had an example of that. I mean, this is again a principle that exists in the BSB ethical handbook. There was a case, I think it's about the first case that I ever actually read from Jersey. It was one of the earlier ones in the Crociani saga. Now, I know I got slapped down the other week, quite rightly, by Mark for mentioning the J word in these proceedings. But even, I know he said that, you know, yeah, what else was it going to be? But you know, even you guys must have heard of the Crociani litigation. You probably sat here thinking, so much money goes to the lawyers over there. Why is none of it coming? You know. All right. Oh, right. It's true. That's true. That's true. Yes. All right. Okay. All right. So you're quite relaxed about that then. Okay. But anyway, yeah. So there was I can't remember. There's a very trivial kind of interlocutory application that was being made fairly early on in the Crociani litigation in Jersey, and the advocate that was appearing on behalf of the plaintiff there had deposed to an affidavit in support of the application. It needed an affidavit in support. She deposed to that, and the advocate appearing for senior Mrs. Crociani and various other transient defendants, when they rocked up to the hearing of the court, basically applied to force the advocate to withdraw from representing the applicant there on the basis that she was a witness, she was the one that had deposed the affidavit, and she was presenting herself as the advocate. So she was being the advocate and a witness in the same proceedings. And they then pulled out the then current copy, which I think was an out-of-date copy, but anyway, the Code of Conduct for the Bar of England and Wales that said, "Thou shalt never be advocate or witness in the same proceedings." And the judge there said, "No, that's quite right, really. So we'll have to find someone else for this hearing." So, and it was a piffly little hearing, but anyway, there we are.
Case with Gordon and Mark. Where they're like big friends and they're not. I can't remember. Oh yeah, they were going cross-examined. That's right.
Yeah.
That's right.
I think it's generally.
I forget who the other advocate was, but one of our advocates cross-examined. It was
Yeah.
Gordon that did another one of his partners.
Oh, really? Okay.
Yeah.
Okay. All right. Well, I mean, you know, the case that you've got there, the Ogier and Jeffries, is really kind of against that. Although, to be fair, the kind of criteria that they're looking at there would be what? Client protection. So, like use or abuse of confidential information, that type of thing. And I know professional reputation. I mean, you know, holistically professional reputation. Seeing, you know, how would it play out? Would a member of the public, reasonably informed about the proceedings, conclude that perhaps the cross-examiner wasn't doing the full job, wasn't giving the full Monty, basically, because it's a member of their firm and they don't want to upset the apple cart? There's also points that come out from Ogier about things like the relationship of one partner to another, that kind of almost sits on top of your duty to the court, your duty to the client. How are you going to reconcile? It's just another added nightmare for you to deal with. But no, I can see if you can persuade the court that you're
I can't remember.
gung ho.
I'm sure Jess will talk about the length, because a lot of the cases like this come out of the partner moving from one zone to overtime.
Yeah.
Cases with him.
Yeah. Yeah, I mean, you see it all the time. Firms merge, fall apart, people leave, take clients, leave clients, act against former clients, etc. Yeah. Okay. Yes. All right. Yeah. The interesting part about the Odria case then is, as it says there on page 17, Deputy Bailiff found the most significant issue was that last one, which is, public confidence in the administration of justice. Is a proper job being done here? How would the public view the idea of you cross-examining someone that you're, working for, another partner or even an employee of your firm? Would they think that there's some kind of cover-up? You're soft pedaling because you don't want to upset people. I think that's the big concern there. And I think another example of that is the Havilay case, which involved Ozans. And that's, I think, referenced in a couple of pages' time. Bottom of page 20, top of page 21. That wasn't so much. It kind of touched on that. You can see there's a quote towards the top of page 21. It was difficult to see, towards the end of that quote, it was difficult to see how, having been the principal legal advisor to the company and also having been one of its directors, you can now contemplate cross-examining his co-directors and other officers in litigation. So there's an obvious, it's a different situation, obviously, because it's an external company, not the firm. But yeah, there's obvious concerns about doing that. So I would have thought that particular case would be probably the exception rather than the norm. Yeah.
So it was kind of a view that one can't
pull another one out. Yeah.
There's a limited source of these.
Yeah. Yeah, but obviously one has to be reasonably pragmatic about that. And yeah, there will be other examples that we'll see of that this afternoon. I see it is now after 1 o'clock, so we're going to stop for lunch, come back at 2. Jessica, I hope, will be here then. That's my expectation. And then we'll run through the rest of this, possibly a bit faster. So was that 2 hours to do about a third? So 4 hours? No, we don't have 4 hours. We've only got 3 hours. Speak faster. Less stories. Less stories. Yeah. Fewer questions. Right. So back at 2. I'll cut 5 minutes out of your lunchtime. Back at 2. You won't want to be out there for very long anyway. So. Some shopping. Okay. I don't know where anything is. I mean, this is like a kind of desert around here. That's it, is it? Yeah, okay. Excellent. I said to the cabbie on the way in from the airport this morning, I don't have to take up your lunch time. I said, can you take me somewhere, or tell me where there's somewhere, I said, tell me where there's somewhere I can get a coffee. Says, I can take you somewhere to get a coffee. Just tell me, because I've got no idea. He said, no, he made various suggestions about where he could take me. But I said, because I don't want to go down those chuffing steps again. Yeah. That was a lesson learned. Yeah. Oh dear. Yes, apparently. it's not very nice weather, is it? I mean,
No.
might as well be inside in the warm and dry.
Well, I think it's fair to say that everybody else in the room is a fair amount older than Rachel, which looks really nice, so they have some reason.
Yeah, yeah.
The usual to deal with.
Well, I know when we had, I said was it last Sunday, we had Elaine Gray come in as our adjunct, and yeah, she was saying I think she said she's a bit rushed in arriving. She wanted to get here sooner, but she had to, I think, was it walk the dogs and dispose of the children, or possibly the other way around, I don't know. She was going to have to leave by, was it 4:30, I think? Because we should have gone until 5. In fact, I think we finished at 4. But anyway, yeah, she was going to have to leave by 4:30 to, again, either collect the children and walk the dogs again, or vice versa. I didn't know. So, yeah. Well, that's it. You know, people have lives, don't they? You've got things that they need to do.
I mean, in this room, we've got some very senior lawyers.
Yeah, I kind of, you know, picked that up, really. Yeah. It's weird because obviously if you think about people as like trainees or like pupils and that sort of thing, then you are thinking, I mean, in my head, generally I'm thinking of someone like 21, 22, maybe 23, somewhere around there. Yeah, it doesn't know they're from their elbow, you know. But these guys, I mean, it's very apparent to me, really the first day of the first weekend with civil procedure with them, that they are, you know, fully geared up and ready to roll, basically. So, yeah.
You don't take the step to come off the 5 or 6 years under your belt.
Oh, okay, right.
So it's more something you do later.
Oh, you don't just swing and go, hey guys, I'm going to.
Rachel and I did the English bar.
Yeah.
So we let these people
Yeah. Right. So is this like the equivalent then? Because I know Elaine was she, yeah, or was it maybe it's Mark, because he was here on the Saturday. I think maybe it's Mark was talking about having because you have pupils. That's the term, isn't it? Yeah. Okay, and that, so does the BSB recognise this? No. So you're just abandoning.
You have to be affiliated with team.
Yeah.
The BSB
Yeah, forever. Yeah.
But one of the requirements to do this course is you either have to be a barrister or a solicitor. But for just you can call yourself that once
you've done your training contract, yes.
Whereas it's the reverse.
Yes.
So,
yeah. Happy days.
I tried to keep it in England.
No, that's interesting. So, but are you kind of a Guernsey native then? Right. Okay.
But yeah, it's different.
Yeah.
But most of the people through are corporate lawyers. And I'm a criminal family lawyer.
You are, okay, all right. So I'll be seeing you again in January then.
Yes.
Okay. Yeah. Still trying to, as you probably realise from its absence on the VLE, still trying to put the study guide to bed. It's been such, I can't even begin. Let's stop recording.